Everybody, attorney Zach DeLerno here with my law partner Logan Greenberg, and today we're actually going to go over some of the most frequently asked questions that we get regarding power of attorneys. I think this video will help a lot if you have some of these questions that we receive a lot, to kind of go over those questions and what the answer is, to kind of guide in a sense of what you would do in that situation in drafting a power of attorney. The first question that I get a lot, that we both get a lot, is does my agent have to be present? Logan, how would you answer that question if somebody came in here and they wanted to do a power of attorney and they wanted to assign it to their brother? Does their brother have to come in here and be present?
Yeah, so question we get all the time, particularly when someone has a sibling that they want to be their power of attorney. Does he need to come in? You know, logistically it's hard, he's got work, and the answer is no. Whoever you're going to determine to be your power of attorney, they do not have to be here on the date that you sign the documents that make them a power of attorney. Only you need to be here to actually sign those documents. And furthermore, the other question I get attached to that is, will that person who I want to be my power of attorney, my brother or my sister, they don't even live in Louisiana. They live in Texas or they live in Illinois. Can they still be my power of attorney? And the answer is absolutely yes. So wherever they are, that part doesn't matter as long as you are here making them that power of attorney.
And Logan's absolutely correct on that. And the reason is you have to think, when someone is granting or assigning someone the ability to be their power of attorney, it's a power that they are giving, and the agent doesn't necessarily have to accept that power. They can renounce it. They don't even have to know that. You could wake up one day and realize that someone named you as their power of attorney. That doesn't mean you have to go forward with it. It's a power that's kind of been granted to you. And that brings me to the second question that we get most often is, can I have multiple agents? Can I have multiple power of attorneys? For this exact reason, what if one can't serve, can the other serve? So the answer is yes, of course. You can have what's called co-power of attorneys. So you could draft a power of attorney that says your brother is an agent and your sister is an agent, and they can act with joint power equally, so they have to make those mutual decisions. Generally kind of advise against that because you might get into a territory where there's some conflicting powers, but some people feel better if all of their children are making decisions. So you can absolutely have co-power of attorneys where they have equal powers, or you can have co-power of attorneys, and we call it, or they can act independently of each other. So someone is named as a power of attorney and they live in Texas, the agent lives in Texas, one lives here in Louisiana. Well, the one in Louisiana would have the ability to act without the other. Again, they both still have the powers to be a power of attorney. So keep in mind, you can have multiple agents. They don't have to be here when you execute a power of attorney, when you name them. And then the third question, Logan, that we get a lot is, should I have a backup agent?
Yeah. So a lot of people say, should I have a backup? The legal term we use is a contingent agent. So somebody who becomes the power of attorney contingent on something happening. And the answer is absolutely. So we always advise that you have at least one, let's call it the backup power of attorney. And the reason we advise that is for several reasons. Number one, with the simple scenario where you grant somebody the power to be your power of attorney and then they refuse that power, or they what we call renounce it. They say they don't want to do that. And if you don't have a backup power of attorney, then of course you're left with nothing. And then the other scenario that happens a lot is in estate planning and these types of documents, you may come up with a power of attorney today, and that document you want to stay in place for many years. Let's say you want someone to be a power of attorney for you for 10 years. Well, life comes at you fast. And so that person may move out of state and not know that they're the power of attorney when the time comes that it's necessary, to use it. Or that person, unfortunately, if we're talking about many years, that person may pass away. And so you may say, well, I would like my brother to be my power of attorney, but then he passes away 7 years from now. And if you don't have a backup plan in place, then really you've got nobody else who can perform whatever you needed him to do for you. And so the general rule of thumb in all estate planning, and certainly the rule that Zach and I ascribe to, is backup plans. You should have a backup to the backup plan, just in case, because you want to make sure that you create these safety nets for yourself, and a plan that will, be set in place for any type of eventuality.
Absolutely. And then one of the more, it may seem like an obvious answer, but it's certainly a question that we get a lot, and it deals with capacity. Can I do a power of attorney for someone? Meaning, like, can I do one for my grandmother, for her? And that kind of goes against the whole concept of a power of attorney. And so what I mean by that is the person who's executing one needs capacity. And the reason I say that is sometimes we get into these situations where, mother is going into a nursing home. She's now lost the ability to make her decisions. The family realizes it would be easy if they now had a power of attorney. The problem is it's too late. She wouldn't have the ability. She has to make that decision who she assigns. She has to have that mental capacity. If she's certified by a physician to not have that ability to do that, she can no longer do a power of attorney. And this is the reason we do these videos, is to stress that point. Get it done early. Get it done now. We have some more videos that you'll see on the site that show how heart-wrenching and how difficult the interdiction process is, and you can avoid all of that by doing a power of attorney. So, the answer to that is they need to be able to have the ability to make that decision and assign that person the right.
And so right on top of the general rule of thumb of always having a backup to your backup plan is certainly we encourage everybody to be proactive. So not only do you want to have a backup to the backup plan, but you want to be proactive about putting your plan into place. And so generally speaking, if you're going to put your plan in place when you actually need it, it's too late. And so we encourage people to think about these issues and what they may or may not need, and to ask us about what they may or may not need before the time actually comes where it's time to put the plan into place.
With that said, you guys, I hope some of these answers helped you out on some of the most frequently asked questions we get on power of attorneys. If you need any help or guidance, please feel free to give us a call here at Sunrise Law Group.
Thanks, guys.